Good morning, ladies and gentlemen, and thank you for joining us for our latest webinar. We put this webinar together to help companies and business owners with some of the tax, employment and immigration issues that we face in today's post-Brexit landscape. We'll be taking a whistle-stop tour of the impact of the Uber tax ruling on the gig economy, the changes to IR35, the legal pitfalls associated with engaging individuals as self-employed contractors or zero-hour workers, and the immigration points-based system. Our speakers today, we're joined by Excello Law, and we have Sonia, who is an immigration solicitor specialising in helping clients with UK immigration matters, and Nello, also from Excello Law, who is an employment lawyer specialising in both UK and global businesses. Nello works with companies in a number of sectors, including professional services, manufacturing, education, travel, and logistics. Victor Dorp is one of my ABG partners. He's our VAT and tax partner, and is a highly respected tax professional and public speaker. And Victor works very closely with business owners and high net worth individuals, and he looks at all kinds of tax planning opportunities. Hopefully we'll have time for a Q&A session, and you can submit your questions in the box shown as Q&A, believe it or not, and then I'll endeavour to take those questions after the various speakers have spoken. If we do run out of time, please submit your questions anyway on the survey link you receive at the end of the session, and we'll get back to you afterwards. I'm now passing over to David Glass of Excello Law.
Hello, everybody. I just wanted to speak very briefly on behalf of Excello Law to say how delighted I am that we're doing this new session with ABG. This is the second session that we've done together. We did one in the summer in June on trading out of the pandemic, although the pandemic is sadly still around somewhere. We have moved forward, and it is good in my view that we are talking about the issues of recovery, supply chain resilience, labour shortages, the gig economy, immigration opportunities, and not stuck where we were many months ago. I'm delighted to welcome our Excello guests, and I'm delighted to be working on behalf of Excello with ABG. I'd now like to pass you to Sonia, who is our immigration specialist, who will then be followed by Nello, and enjoy the session. Thank you.
Hi there, good morning. I'm Sonia. I'm from Excello, as discussed. I'm just going to jump straight into it, given that we're quite limited on time this morning. I'll start with the contents page, where I'll just do a quick run through of what we'll discuss. It will be, first of all, the EU settlement scheme and the right to work checks, anything that you may need to consider as an employer. We'll then go on to briefly discuss the visa options in terms of the points-based system and other options that may be available for business owners. We'll then discuss the sponsor license itself, on when and how to apply. We'll briefly go over the seasonal workers policy at the moment. Then we'll move on to the global business mobility visa, which is due to come out next year, and a quick overview at the end. So, in terms of the EU settlement scheme and the right to work checks, you'll all be aware, obviously, with Brexit, a lot of changes have been made. If employees have not been living in the UK by the 31st of December 2020, they are not going to be eligible for the EU settlement scheme. And then they need to have applied by the 31st of June in order to be eligible for the scheme. So this is quite a lot for EU nationals to have done in terms of being on the scheme. If they are, you can do the right to work check via their share code. I've popped the link in there for you to utilize. Otherwise, you can do the normal right to work checks, take in their biometrics cards, their ID, passport, etc., the usual confirmations, and keep good records. It's very important. These applicants will not require sponsorship if they are under the EU settlement scheme. However, if they have missed these dates, they are likely to be considered as overseas workers and will require sponsorship. And if we could move on to the next slide, thank you. In terms of the points-based system, you'll see I've slightly categorized each route. We've got sponsored routes, other work routes, and investor, business development, and talent routes. The first column are all the sponsored routes in which you will require to be a licensed sponsor in order to take on employees. Now, the skilled workers, the intra-company transfer, and healthcare worker routes all have minimum salary requirements. They all have minimum qualification requirements and maintenance requirements, as well as English language requirements. So these must all be considered prior to taking on any overseas workers. In addition to that, you need to be sure that the position is one that can be taken on as a sponsored route. Not all occupations are accepted, especially if they're below the required regulated qualifications framework, level 3 for the skilled workers, and intra-company transfer. It's a minimum level of level 6, which is the equivalent to a bachelor's degree. So the requirements are still quite high for the intra-company transfer. Skilled workers a little bit lower. The Home Office have given a little bit of leeway for that, just to allow employers to onboard overseas workers a bit easier. In terms of health and care workers, it's the usual requirements. You will know if you are onboarding health and care workers. Again, they have to be under the specific categories and paid a specific minimum salary and meet certain requirements. In terms of temporary work visas, there are quite a few. They are all very specific routes. If you need to discuss them, please find a legal advisor to go through them. They are more likely to be for charities, sports persons, and ministers, etc. Now, the other work routes that we have is the frontier worker route. Now, this is a new route that was brought in post-Brexit for EU nationals who had been working in the UK prior to December 2020, but they do not predominantly live in the UK. So they still live in the EU, but have work here in the UK. It's a very specific route, and there are only a few people that will actually fall into this category, namely because you need to provide evidence that you had been working in the UK prior to Brexit. The other route for the other work routes is the graduate visa, where you require to have had a tier 4 sponsorship prior to applying for that visa. So again, that's very limited. They do not require sponsorship, but they do require previous working in the UK or previous sponsorship. Now, the last column, in terms of investor, business development, and talent, these do not require sponsorship. They are very specific routes for the setting up of business and developing business and talent. Some of these routes are actually closed off for new applicants now, namely the Entrepreneur Tier 1 visa. The reason why it's still there is because you can still apply for an extension if you're already on that visa. The final one on that list is the sole representative of an overseas business. This visa currently allows one applicant to come to the UK to set up a new UK branch. Again, that does not require sponsorship. However, the rules are quite strict on that route, and we're due to hopefully see changes in the new year. I will discuss this in a bit later. Now, all very well, now we know the sort of categories in which we will require a sponsor license. When do we apply for the license? The Home Office's stance is now. Apply as soon as you are even considering taking on any overseas workers, and you cannot onboard any employees that are overseas workers until you have a sponsor license. The current processing time is around 8 weeks. I'll give you an example of an application that we just had. The Home Office came back with a decision on exactly the 8th week, which is a bit frustrating because obviously companies are struggling to with staffing. Really, we're having a lot of issues with that, but with the 8 weeks decision time, you have to be quite on the ball, quite ready to get the application in and be willing to wait a little bit of time. Now, the application is all done online, and the evidence is actually submitted by email, and there's a limited number of documents that you can provide via the email, naturally because of the size limitations. So it's very important to be very specific with your evidence and meeting the requirements for the sponsor license. The requirements are going to be very specific depending on the size of your company. It's categorized into small and medium and large companies, and the fees will be relevant to the size of your company, application fees, potential immigration surcharges, and the issuing of certificates of sponsorship. All of these things incur fees. Unfortunately, it's just the way that the Home Office works. So these are all the things to consider when applying for a license to make sure that your company is in a financial position to do so. In terms of compliance and the immigration rules, it's very, very important that you understand your obligations as a licensed sponsor. There are around 10 documents that will guide you through being a licensed sponsor, and it's important that you have somebody who will sit down and take the time to understand them. If you submit an application and it is refused, it's a 6-month cool down before you can reapply, which is very difficult for a lot of companies, especially when they're understaffed. So it's very important to get legal advice prior to submitting an application due to this 6-month cool down. Thank you. In terms of the seasonal workers, at the moment, the Home Office have provided a few extra routes to allow seasonal workers to come into the UK. Unfortunately, a couple of the cutoff dates have already passed. That would be for the HGV drivers who are transporting specifically food, and poultry workers. Now, these have already passed. However, you still have the option of workers in the edible horticulture realm. They can come to the UK for up to 6 months. There's currently no cutoff date, but there is a quota of 30,000 applicants allowed. So basically, if you are in need of this, you will know. You have to be an approved scheme operator and be endorsed by DEFRA and licensed by the Gangmaster and Labour Abuse Authority before you can apply. So naturally, individual employers and organisations won't be eligible to apply for this license under this route unless they are already part of the scheme operators. The final option we have, which we still have time to apply for, would be working in the pork butchery realm for up to 6 months. Applications need to be in by the 31st of December. 800 visas have been made available for this. It's very specific. So if you do need assistance with this, please again find a legal advisor to guide you through the requirements for these sort of short-term temporary visas. Okay, now, as I said, there'll be some changes coming up in round about spring 2022, and that will be the Global Business Mobility Visa. This visa is really just the intra-company transfer, the intra-company graduates, representative of overseas business, temporary work, and international agreement routes to be all consolidated into this one category, Global Business Mobility Visa. They are in existence as it is. However, like usual with the Home Office, they will shuffle and rename and make some amendments. The Migration Advisory Committee have made some suggestions in terms of these new rules. One of them being that for the overseas, the sole representative overseas business visa, currently you're only allowed one applicant and one person to come to the UK to help establish and set up a UK branch or subsidiary. The Migration Advisory Committee has actually suggested that it is increased from one main applicant to one main applicant plus 4 team members. So altogether a team of 5 to come to the UK to assist with setting up a UK branch. That makes a lot more sense considering usually we do, as a company, we need a team of people to review and assist with setting up anything. So hopefully the Home Office will take that on board and we will see that change. We currently don't have any confirmation that they will take on board the Migration Advisory Committee's suggestions. So if we have any updates, we will post that in due course. Now, the rules are still developing, as you can see. Policies are being amended and updated regularly. It's really, really important to get legal advice if you're unsure, namely because of the penalization of cool downs, 6-month cool downs for applications or rejections, in terms of losing your fees, in terms of losing more time. I would be 100% recommending getting legal advice or assistance on anything that you're not sure about, even if it's just a quick chat, just to make sure that you're doing the right thing. And we've had a lot of issues with companies trying to submit applications themselves and finding their applications being rejected because there's been a lack of evidence or a lack of information being provided. The Home Office will give you an opportunity to provide extra information, and they will ask you if they're not sure about something. However, if they are not satisfied with your answers thereafter, they will reject your application, and it will be a bit of a wasted exercise. In terms of compliance, it's very important to keep great records of absolutely everything you're doing, from how you recruit people, the invoices for any kind of recruitment that you advertise, all job descriptions, all right to work checks, including attendance sheets, how you will monitor attendance, things like that. They are all taken into consideration by the Home Office. So it's very, very important to have immaculate administration in terms of your sponsorship duties. Audit checks have continued during COVID. They've not been physical, office attendance audit checks. They have mostly been via online, which can be very difficult to show information and full records. So this is why I'm saying, please keep a note of all documents, all kinds of invoices, and any actions that you have done should the Home Office request it. And again, seek assistance to navigate any complex rules that you may have. And what I'll do is I'll pass you on to Nelu, our expert tax employment specialist.
Thank you, Sonia. So I'm going to look at the benefits and pitfalls of employment and self-employment, which are at the opposite sides of the spectrum, and workers who are somewhere between the two. Now, you're going to get a copy of the slides at the end of the webinar, so I'm just, in the interest of time, just going to highlight some of the key points. Now, whether an individual has the status of an employee, a worker, or a self-employed contractor isn't always clear, and that's partly because the definitions have largely developed through case law, which has been very fact-specific. Add to this, in recent times, we have a number of different models of working. For example, we've got the gig economy, casual workers, zero-hour contracts, just to name a few. And all of this has added to some degree of confusion about the exact employment status of an individual. Next slide. So I'll look at each of these three categories in more detail in a moment, but before I do that, I just want to look at why employment status actually matters. Let me move on. Now, only employees have the right not to be unfairly dismissed and receive statutory redundancy payments. Now, the maximum unfair dismissal compensation award is currently £89,500, approximately about that amount, or a year's salary, which is the lower. And the maximum statutory redundancy payment is approximately £16,000. Only employees are covered by the ACAS Code of Practice on Disciplinary and Grievance Procedures. And whilst employers owe employees duties relating to health and safety, these duties don't necessarily extend in the same way to self-employed contractors. Employers are required to take employers' liability insurance to cover the risk of employees injuring themselves at work, whereas workers and self-employed contractors are not usually covered by this insurance. And there are different implications for handling personal data under the data protection legislation, depending on whether an individual is an employee, a worker, or self-employed. Next slide. However, workers also are covered by some important employment law protections, and that includes in relation to paid holiday and national minimum wage. Whereas self-employed contractors don't actually have any rights for paid holiday, no national minimum wage, no statutory sick pay, no unfair dismissal rights, and no right to a pension under auto-enrolment. So in short, what we can see is that employees have far greater rights than the self-employed and workers, and with this comes greater potential liabilities for businesses. Next slide. So how do we determine who is an employee and who is a worker and who is a self-employed contractor? There's often a misconception that you just rely on the contractual documents and what they say. So if you have an individual who willingly agreed to be a self-employed contractor, well, then they must be self-employed. But that's not the case, because what you actually have to do is look at the reality of the working arrangement. And of course, this is going to differ from case to case. And for an employee to be for an individual to be an employee, at a minimum, there has to be three things: personal service, control, and mutuality of obligation. Now, personal service is when an individual agrees to provide their own work or skill to an organization, and in return they get paid. Control, this means the organization has a degree of control over the individual. This includes, say, the power to decide the type of work that needs to be done, when it needs to be done, how it's done, and where it's performed from. And as a minimum, there also needs to be mutuality of obligation. This is the obligation on the organization to actually provide work, say from 9 to 5 on Monday to Friday, and the obligation on an individual to accept and perform the work during those hours. But this doesn't stop there. Other factors that also need to be considered include: does the organization actually provide and maintain the tools or equipment used to perform the work? And is the individual integrated into the business? For example, do they have a company email account? Are they involved in decision-making process? Do they get a company uniform with a company logo? Do they drive a company vehicle? If the answers are yes, then they're more likely to be an employee. Now, if you want to engage someone as self-employed contractor, then what do you need to bear in mind? Well, it's more about the freedom that you give them, and the more freedom you give them, the better it is. And by freedom, we're looking at they can choose how they carry out their work and their own hours. They have the freedom to choose whether they actually accept or reject work. They've got the ability to set out their own fee or price. There's no exclusivity that they only work for your organization. They can work for another organization, including competitors, whilst engaged by you. And if they're unable to actually perform their work, they can arrange for a substitute with, say, the same skills and experience to do that work on their behalf. And they use their own equipment, say their own laptop or their own tools. Now, if all these factors are satisfied, then an individual is likely to be a self-employed contractor. And as we've seen, there's some significant advantages from an employment law perspective of engaging staff as self-employed contractors. So on the one hand, we've got employees who've got a number of rights. And on the other hand, we've got self-employed contractors with far less rights. So who on earth are workers? And this is quite a difficult question, even for the courts to answer. And that's largely, as I said earlier, because a lot of the law has developed from very fact-specific cases. The next question, I suppose, is once you've defined who is a worker, well, what rights do they have? And actually, this is when the gig economy becomes sort of a good place to look, because most recently, this is where these questions have arisen. Now, what is a gig economy? Well, it's a job that is temporary or that has an uncertain future, a labour market characterised by the prevalence of short-term contracts or freelance work as opposed to permanent jobs. And the Department of Biz also has a very specific definition which says it's the exchange of labour for money between individuals or companies via digital platforms that actively facilitate matching between providers and customers on a short-term and payment by task basis. Now, we know the gig economy is often associated with companies using new technologies to promote their businesses, mainly through apps, and the companies such as Amazon, Deliveroo, and Uber. But it's also becoming much more prevalent in other sectors, such as social care, retail, cleaning, and construction. Next slide. Next one. So until February this year, most of the companies that engage staff in this way were generally engaging them as self-employed contractors, and therefore these individuals had very limited employment rights. And that was the case for Uber drivers until a number of those drivers actually challenged this and argued that they were workers and entitled to, therefore, the national minimum wage and paid holiday. And the Supreme Court actually agreed with the drivers. And what the court said is, you need to consider a number of factors, but actually where you start from is the actual working practices, more than the written contractual arrangement. And because the drivers were in a position, as the court described as subordination and dependency, with Uber exercising significant control over how they did the work, then the drivers weren't actually self-employed contractors, despite that's what their contractual documentation is saying, but they were workers. And as a result, they were entitled to paid holiday and the national minimum wage. Now, as you can imagine, this has sent serious financial implications for those companies and for the actual individuals and the whole gig economy. There's also been a High Court ruling this week also involving Uber, which has strengthened the effect of the Supreme Court ruling made in February. So the whole sort of emphasis is in the gig economy that we are now looking at moving away from the sort of traditional self-employed arrangements to individuals being retained as workers with those additional rights. Next slide. Next one. Oh, back, sorry. Right, so finally, during lockdown, a lot more businesses have clearly started to move over to the gig economy model for a number of reasons, either because their business and has dictated that's where demand has seen sort of an uptake in terms of how people want their services and goods. There are now nearly 5 million individuals working in the gig economy, and it appears that this will continue to grow. Lockdown and post-lockdown, as we know, have forced businesses to reevaluate and adapt how they provide their service and products. And this is now reflected in how companies are actually hiring staff. So one of the main takeaways that I'd like you to take forward to hold from today is that before you engage someone, consider carefully the actual nature of the working arrangement and reflect this correctly in the contractual documents. If you've traditionally taken on self-employed contractors or have self-employed contractors working for you at the moment, don't assume that all new hires will have the same status. They may in fact be workers with those additional rights. If your current model is that you have that your staff are mainly employees, but they've actually adapted the way that they're working, maybe they've moved on to do more project work, maybe they're using their own equipment, it could be that they're actually now setting the times that they work, etc. Then it may be that those staff that were employees could now be defined as workers or self-employed contractors, and you may have an opening opportunity to move them over to different types of contracts. This is an evolving area of law. It has some serious financial consequences for companies and individuals, depending on how their employment status is defined. So it's really important to keep on top of this and keep everything under regular review. With that, I'm going to hand you over to Victor.
Hello, ladies and gentlemen. Good morning. My name is Victor Dorp. I'm the tax partner at ABG, and I'm going to talk a bit about the tax and employment, self-employment, which part of which is a bit of a recap of what Nilu has said. And in fact, if you were listening carefully there, you'll notice that. But there is a major difference between tax and employment law in that under tax law, there are only two statuses. There's employed or self-employed. We don't have the third worker status, which now is part of employment law, or perhaps always has been, but has only now just been recognized. So you're either employed or self-employed. If you're not one, you must be the other. There is no third category. It's important because, back please. It's important because if you're employed, then PAYE and NIC come into play. Now, that's normally spoken about as if they're deductions, and I've called them deductions, but in reality, they're not deductions. They're an obligation on the employer who can then seek reimbursement from the employee by deduction from their salary, but it's not actually a deduction from their salary that they're paying over to HMRC. It's a liability that the employer has to pay that, and then he can recover from the employee. If you're self-employed, there are no deductions at all. So a lot of employers or contractor or clients, whatever the right word is to describe the ultimate end user, they would rather not be involved in PAYE and NIC. And formerly, what they used to do was say, we'll take you on, provided you use an intermediate personal service company, i.e. your own company. And the reason for that was that a company cannot be an employee. It was thought a company could not be an employee. And if a company is not an employee, then the client doesn't have to make any PAYE and NIC deductions. So that was a way of getting around the question of how I got an employee or a self-employed person. You ensure they weren't an employee by insisting they use their own personal service company. Now, the law has moved on a bit here. What I'm trying to do is put the bit of historical context and the logic for it. Next slide, please. So employment and self-employment, Neil has spoken about this. The words used in the is contract of service for employment and contract for services is for self-employed people. And it's all about the case law, and the case law, as Neil said, is very fact specific. There are these different elements that you look at, apart from what used to be called the Holy Trinity, which is personal service, degree of control, and mutuality of obligation. There are other parts, and I've mentioned them there. There's the substitution issue. There's also a very interesting point that if you're an employee and you make a mistake, well, you're not personally liable. Then no one's going to ask you to make a payment to the firm because you've made a mistake. They're not going to ask you to come in at the weekend in your own time to put it right. Those are self-employed people issues. There's also the question of integration into the client's business. That's another important part that Neil mentioned. Next slide, please. And this is important because Inland Revenue asked these questions. They would love everyone to be under PAYE and NIC. So they will look at your staff and say, or the people who work on your premises, and say, are they really self-employed? And they will go through these very tests that Nilu and I have just discussed. A few little points about some of those tests. Control, it's what the employee does and where he does it. But as recent case law has shown, it's not whether the employer, inverted commas, actually controls every aspect of the work. You know, put your pencil here, put your rubber there. It's not that. It's just that he has a contractual right of control over how you do your work. And it's not actually saying turn left here or turn right there to an Uber driver. That's not the control we're talking about. It's whether there's a sufficient framework of control. Next slide, please. Under mutuality of obligation, which is still going through the courts at the moment as to precisely what it might mean, it's generally accepted that this means the employer has to provide work if you're an employee, and the employee must do it. You can't say, oh, I don't fancy that, but actually, I think I'll go home now. Yet, that's not what an employee-employer relationship is. The employer must provide work, the employee must do it. Next slide, please. There is an employee cannot send their Aunt Mary in because they're not feeling very well. It has to be done personally. No substitute if you're an employee. Employees not personally liable for errors, can't be forced to rectify them in their own time or at their expense. Next slide, please. Integration is something the Revenue are pretty hot on, actually. Is someone integrated into the firm's business? And this can include, do you have your own office space? Is there your name on the door, perhaps, assuming there still is a door on your office premises? You have a business card, a listing in the office telephone directory. Do you have an email address with the firm's name on it? All those things are integration into the client's business. Next slide, please. So we come back to the fundamental question for tax is, who is it who applies PAYE and NIC if indeed the person is an employee? If you've gone through the test and you've said, oh, they're not an employee, then you don't have to worry about PAYE or NIC. But if they are an employee, then you, the client, have to worry about this. And you say, but we've insisted they use a personal service company, so our contract is with a company, and a company can't be an employee, so there, no PAYE, bad luck. Now, what the Revenue have done, or what the government have done, is they've changed the rules here, so that simple analysis no longer works. Next slide, please. From April 2017, what they said was that if the ultimate client is a public sector person, they're now a deemed employer. So you don't look at an employer-employee relationship. You say, but you're a deemed employer. Even if there is a personal service company involved, we want you to apply PAYE. And the test you use is first of all, is the PSC at least 5% controlled by the individual worker that you're going to have on your premises doing the work? If that's the case, and if you took away the personal service company, there would be an employer-employee relationship, looking at the tests we've just been talking about, then the client is a deemed employer and has to operate PAYE and NIC. That's the basic premise, although that obligation can be passed down a line if they're intermediaries, normally agencies. So you've got the actual worker himself, the personal service company, an agency, perhaps another agency, and then finally the ultimate client at the other end. These obligations can be passed down, and that's also important. So if you're an employer or a potential taker-on of somebody who is going to be the worker, you would want to pass that on if you didn't want this responsibility of PAYE and NIC. Next slide, please. Now that was 2017. From 2021, 6th of April 2021, this very year, has now been extended to non-public sector bodies, i.e. everybody else, the normal everyday company or business client that we are or that we're familiar with. And it applies to companies that are non-small. So if you're a medium or large client, I'll tell you what a small client is in a moment. But if you're a small client, you still don't have to worry. But if you're not a small client, you have to say to yourself, oh dear, I've now fallen into that new legislation of being a deemed employer. I now have to look at the ultimate worker and say, if I took away all the intermediaries, would I have an employer-employee relationship with this guy? And if the answer is yes, then you've got a PAYE and NIC issue here. Now, you can lay off your PAYE and NIC in the same way as public sector employees down the chain. So hopefully that's something that you will want to do, but you can no longer protect yourself simply by saying, I'm making a contract with a personal service company. You have to take away the companies, look at the relationship that you would have had between the ultimate employer and the ultimate worker and say, is this an employer-employee relationship? Next slide, please. So what is a small company? And the answer is, there they are. It's all about turnover tests, balance sheet total, average number of employees. If you're one of those, then don't worry about it. The new rules simply don't apply to you. If you're not one of those, then you have to go a little bit further and say, every single person I pay money to for services, are they really an employee or are they really an employer? If I take, or rather really self-employed, if I take away all the intermediate companies and look through it, what is actually my relationship? Or what would my relationship be with this person? Next slide, please. So here's a bit more detail about how this works. The ultimate client has to look at this person, be they a window cleaner, someone who's come in to fix the leaking taps, or someone who's come in on a temporary basis, and say, employment or self-employment, what is it? And you do what they call an employment status determination. Written results are really important to prove that you've actually gone through these tests and you've come up with an answer that makes sense. You can use the HMRC CESS tool, which nearly always actually provides the answer that you're an employee, but don't worry about that. You don't have to use it. You can use your own research and your own methodology. But once you've done it, you issue a status determination statement to the worker and say, here it is, I think you're an employee. I think effectively you're an employee, even though there's all these intermediaries, and if you do, then the worker can appeal it if he doesn't like it. But once you've done that, and once you've said he's an employee, that's your decision, then you have to apply the PAYE and NIC. But you can pass this status determination statement, as I've said, down a chain of intermediaries and also pass down the PAYE and NIC obligations with it. But you should keep robust records of both the status determination statement, your meetings, and any transfer of obligations to an intermediary. The revenue will look for PAYE and NIC, and they'll try and get it from whoever they can. And a message. Next one, sorry, umbrella companies. There we are. There is an exception to this, and they're very popular, and they're called umbrella companies. Now, why an umbrella company is not subject to off-payroll working is because the worker doesn't have at least a 5% ownership in the umbrella company. So the legislation doesn't require off-payroll working to apply. An umbrella company is a company that employs the temporary worker on behalf of an employment agency, who then provides the worker to its clients. So you've got this break in contracts that you don't have with a personal service company. You've got the break in ownership that you don't have with a personal service company. So, and it's the umbrella company itself that will account for PAYE, but not the ultimate client or anyone else in the chain. So that's quite important. If you are the ultimate client and you're trying to say, I don't want to apply PAYE, what do I have to do? The answer is you might like your workers to use umbrella companies, and that is why they're rather popular at the moment. Next slide, please. And that's basically it. If you are an employer and you don't want to operate PAYE and NIC, you've got to either go through the steps of ensuring that the link between you and the worker is such that he would have been self-employed, whatever however many intermediary companies or entities there might be, or you need to use an umbrella company. Or rather, the employee needs to use an umbrella company, and that's who, and your contract will therefore hopefully not be within PAYE and NIC. This is a very complicated subject, and it's a pretty harsh burden on the employer. But if you're not a small company, this is what you now have to do. And please keep really good records of what you've done to record your decisions. We're always available to help. And the legal note disclaimer, that's me, over and out.
Lovely. Thank you, Victor. Thank you, Victor, Nelu and Sonia, for very, very interesting, informative talks. Hopefully that will give a good flavour of what the subject's all about. I've got one question that's been posted. I think this is for Sonia. If a company is already a licensed sponsor, and has been before November 2020, do they need to do anything to update their license for the new rules?
Yes, I think that's the question for myself. In short, no. If you were granted a sponsor license prior to November 2020, it will be categorized, or you will know the terminology would have been tier 2 or tier 5. Since the new rules have come in, the Home Office will have automatically converted your sponsorship licenses to the new skilled worker category. There's absolutely nothing that you need to do for that, except for continue your compliance and sponsorship duties. So good news for those who are already with a sponsor license.
Lovely, thank you, Sonia. For anyone who suddenly has a question to ask after we're done, after we've all logged off, you can send the question, as I mentioned before, on the survey link, and we'll be delighted to get back to you. Just a big thank you again for our speakers, Sonia, Victor and Nelu. Thank you all for joining us this morning. We look forward to seeing you all again very, very, very soon. Have a good day.